Hi, everyone. Thanks so much for joining us for this panel discussion of the film On the Record. I'm Amy Ziering. I'm one of the co-directors of On the Record. The way this came about, I like to say that our films find us, which is really true. Post Me Too, because Kirby Dick and I, the other co-director, we made The Invisible War and we made The Hunting Ground. So we've made several films in the sexual assault space, and post Me Too, our cell phones started blowing up with people wanting to talk. And so I just flew to Brooklyn and rented a house and brought a crew, and we just filmed people who came in and out all day who said they had stories to share. And we didn't know what we would find. And someone connected us to Drew. As we show in the film, there's this quintuple bind that afflicts women of color when they come forward and report. They're just subject to the same routine misogyny that all women are, is that, in our culture, it's very hard for women to be believed when they speak any narrative, and particularly when they speak a narrative of sexual assault. Second, as a woman of color, they're in a position of lower social standing than white women, and so their voice has that extra hurdle to surmount. And three, as a person of color, the criminal justice system has not been kind to people of color in general. So it's not a system that can be trusted to play fair. Four, obviously, there's a whole history and legacy of mythologies about Black women's sexuality that hypersexualizes them. Another thing, as we show in On the Record, is that all of these things combined, plus on top of that, our society also perpetrates a false narrative of Black men being sexual predators. So it's highly problematic for a Black woman to come forward, particularly if she wants to name an assailant who's Black, because there's this truly profound fear and terror that's not irrational, that in doing so, she will place innocent Black men in jeopardy. And so we've partnered with the ACLU Southern California to present the panel you're about to watch, discussing sexual assault and harassment in the workplace, as well as other environments in which there are circumstances that create unique barriers for those who are assaulted or harassed. Environments such as jails and prisons, assault against sex workers, and in homeless shelters. And then we're going to get into what the law is on sexual harassment and assault in California. We're really grateful that you joined us today for this important, informative discussion. Thank you.
Thank you for joining us today for this discussion, Knowing Your Rights About Sexual Harassment in the Workplace and Beyond. This conversation is inspired by the critically acclaimed documentary On the Record, which can be seen on HBO Max. My name is Bonnie Abaunza, and I'm on the Board of Trustees for the ACLU Foundation of Southern California. I am also the Impact Director for On the Record. I am so pleased to be moderating this Q&A with Aditi Fruitwala and Minouche Kandel of the ACLU of Southern California. Just a little background on these very impressive women. Minouche is a senior staff attorney with the LGBTQ Gender and Reproductive Justice Project at the ACLU of Southern California, dedicated to expanding the rights of and pursuing justice for women, non-binary people, and the LGBTQ people through litigation, policy, advocacy, and community education. She focuses on gender equity issues that intersect with sexual harassment and sexual violence, including advocacy around sex worker rights and safety. Aditi is an attorney for justice, also with the LGBTQ Gender and Reproductive Justice Project at the ACLU of Southern California. Aditi's work focuses on protecting access to reproductive health care, challenging the family regulation system, improving the conditions and treatment in incarceration settings for women and LGBTQ individuals, expanding the rights of pregnant and parenting people, and combating discrimination against women, non-binary people, and LGBTQ people in public accommodations and employment. Thank you both for your phenomenal work. Please note that this conversation will be focused on the law as it pertains to the state of California. Also, this panel will include discussions of sexual harassment that may be disturbing to some of our viewers. Please take care while listening. Okay, let's get started. So, Minouche, I'd like to start with you. This film is about sexual assault in a workplace that was a non-traditional workplace and had an extremely imbalanced power dynamic. Are there examples in your work where you see this type of extreme power imbalance that allows for sexual harassment and assault to flourish?
Yes, one type of environment in which we see extreme power imbalances is a situation in which persons are completely dependent on an institution for their housing. And the most extreme of this type of situation are carceral settings like prisons and jails. And incarcerated persons are at the complete mercy of the institutions that confine them, and they can be sexually assaulted both by the staff at these facilities or by other incarcerated persons. And because of this, in 2003, the federal government passed the Prison Rape Elimination Act, or PREA, which creates requirements for jails and prisons to take steps to prevent sexual assault, to detect it, and to respond appropriately when an incarcerated person reports that they have been assaulted. And some of the important protections in the law are that jails and prisons have to have written policies around preventing, detecting, and responding to sexual assault. And they have to have a designated staff person whose job it is to make sure that they are complying with the law. There are specific protections for cross-gender strip searches and pat downs of incarcerated people, or when staff can do cross-gender viewing of people who are showering or dressing. And really important, the law recognizes that persons who are incarcerated have to have access to support services. So they have to be given access to counselors from a rape crisis center or a similar community-based agency, whether or not they have reported that assault to the officials at the facility. There are requirements around training, so staff have to get special training. And really important, incarcerated persons have to be informed about their rights. When people enter into a facility, they have to be screened about whether they have risk factors for being sexually assaulted or for sexually assaulting someone else, and then be placed in an appropriate housing. And super important is transparency. So institutions have to collect data on the numbers of sexual assault reports they receive, any changes they've made as a result, and publish annual reports. Imagine if all employers had to do that. There are additional protections for transgender incarcerated persons because we know that trans folks are at particular risk for sexual assault in carceral settings. So, for example, prison staff can't physically examine someone to determine their gender status. There has to be special training on how to search trans individuals. Trans incarcerated people can shower separately. And probably most important when it comes to considering housing, whether they should be put in a women's jail, a prison, or a men's prison, the facility has to consider the health and safety of the individual. And then in California, we have an even stronger law that was recently passed that requires state prisons to house people based on what the trans individual thinks would be safest for them. So they get to make the call on whether they would be safer in a men's or women's facility. Even with protections against retaliation for incarcerated persons who come forward to disclose abuse, we know that so many people are reluctant to risk coming forward. And this is true for sexual assault survivors for many different kinds of reasons and in many different kinds of contexts.
Thank you for that great information. Let me continue with you. In the film, we see how Drew struggled with added concerns about accusing a Black man of sexual assault. Can you talk to us a little about other environments that create these kind of unique barriers for assault victims to come forward and disclose their sexual assault?
Yes, we know that the power and control issues that are present in so many abusive situations replicate across environments, but then also there are often particular unique characteristics about specific situations or work environments that create additional or special obstacles. And one of the issues that our office has prioritized recently is sex work decriminalization and sex worker rights. And this is because we very much see sex work decriminalization as a safety issue for sex workers, in addition to a racial justice, criminal justice, and LGBTQ justice issue. And I've been a lawyer for 30 years. I've spent most of my career working to end gender-based violence, and I very much see sex work decriminalization as a way to reduce sexual violence.
Mhm.
This is because sex workers face extremely high levels of sexual assault on the job, both from clients and from law enforcement. So we know that 1 in 3 sex workers report being sexually assaulted while working. 14% of sex workers have been threatened with arrest unless they had sex with a police officer. 1 in 5 have had a police officer pay them for sex. 2% have been arrested after having sex with a police officer. And over a third of sex workers report verbal, emotional, physical, or sexual abuse from a law enforcement officer. Given the fear that they might be arrested because sex work is criminalized, and the reality that law enforcement may have perpetrated sexual assault, we can see that sex workers may be particularly reluctant to report if they've been the victim of a sexual assault. Because of this, our office was part of a coalition of sex worker rights advocates that helped pass a law in California 2 years ago that creates immunity from arrest or prosecution for sex workers who report that they have been the victim of a sexual assault or other violent crime. But this is not enough, and this is why we are working to decriminalize sex work, starting with a bill in California that would repeal the law that makes it a crime to loiter with the intent to commit prostitution. And we see full sex work decriminalization as a way to reduce sexual assault of sex workers.
So let me just ask you again, because I just find these statistics just shocking. Did you say that 1 in 5, so 20% of these sex workers had police officers pay them for sex?
Yes.
1 in
And
5?
obviously,
Wow.
yes. And obviously that's an inherently coercive
Yeah.
situation, because if you know that this person could arrest you if you don't have sex with them, it's really hard to say that that's a voluntary consensual act.
And you said that 14% of these sex workers were threatened with arrest.
Yes.
Wow. Okay, Aditi, I'd like to turn to you now with this question. Does the ACLU of Southern California have workplace sexual harassment cases that you're working on right now? Could you tell us about those?
We do, yeah. So this is not a primary focus of our office, but we do have a couple. And when we do employment work, we try to focus on low income employment industries and ones that are male dominated. So sort of like on the record, the industries that are male dominated have that extra level of power imbalance that we see. So we have one case that actually just recently settled that we're thrilled about. That was against the Navy. Our client, Jennifer Atkinson, was a supply technician with the Navy. She had worked there for years. Her entire family worked on the naval base. Her son served in the Navy in Japan. She loved her job. She was really good at her job. She had stellar work performance reviews. And then she went on leave. She had a baby. She went on parental leave. And when she came back, she needed a place to pump breast milk. And so she asked her employer for a room, which is required by law. Every single workplace in the US has to provide a room to pump breast milk. So she, knew her rights and she asked for it. And initially they said, we don't have a room for you. So for weeks she had to pump in her car, which is illegal in and of itself. But then when they gave her a room, every single time she went to pump, she was harassed by her supervisor. From the walk from her cubicle to the room, her supervisor would say just disgusting things to her. Things like, can I get milk with my donuts? Can I hold them for you? Let me come in there and help. Just really, really gross things. So she, withstood that for a couple of months, but the stress of doing that walk and knowing she was going to get hollered at, it caused so much stress that it caused her milk supply to dry up. So she had to go on medical leave, and we filed a lawsuit. And 4 years later, we finally settled with the Navy. We're very, very happy that we got Jennifer just a little bit of compensation and some non-monetary relief for all that she went through.
I mean, that's fantastic that, you were able to settle a case and obviously get some justice for her. But it doesn't make up for what happened to her. I mean, everything that she went through.
It's true. And that is something that's really hard to accept, both for the clients, the people, the impact of people who are going through it, and really for us as advocates that, we are lawyers. We've chosen to do this. This is how we want to create change, but the law can only go so far. It really cannot recover what you've lost. It's never going to give her and other survivors back the pain that has been caused, the harm that's been caused. The most that the law can do is give you money or give you what's called non-monetary damages, which is something like a change in policy or extra training for your employer or something like that. But that's really the extent of what the law is able to do in our court systems.
Thank you for updating us on her case, and our best to Jennifer. Let me just continue with you. As we know, because we've been, helping survivors for a long time, it can be very difficult for someone who has been harassed to come forward. Can you talk about what are some of the legal options for someone who experienced sexual harassment and sexual assault in California?
Yes, absolutely. So now I'm going to get a little bit in the weeds, but since this is a Know Your Rights panel, just bear with me. So there are two primary laws that deal with harassment and discrimination for workers in California. There's a federal law called Title VII and a California law called FEHA, the Fair Employment and Housing Act. There are others as well. There are laws that deals with specifically discrimination on the basis of disability. There are some that deal with discrimination on the basis of age. But since here we're talking about gender and sex discrimination, primarily the laws that apply are Title VII and FEHA. For California workers, FEHA is typically a lot more protective. It's just a more expansive law and it covers more ground. So FEHA prohibits discrimination on a number of bases: race, religion, national origin, sex, gender, pregnancy, sexual orientation, gender identity. The list is quite long. It's intended to be pretty inclusive. So when we say that it prohibits discrimination, that means a number of things. What it means broadly is that it prohibits your employer from treating you as different and less than another employee. So that can look like failing to hire you, failing to promote you, firing you, demoting you, giving you a lesser benefit than they give someone else. And FEHA prohibits discrimination, and it also prohibits harassment. So harassment looks like words and actions that are unwelcome and that change the conditions of your work. One thing I really want to point out, and because I think it's not really intuitive, is that the law doesn't prohibit harassment and discrimination generally. It only prohibits harassment and discrimination that's based on your identity. So sometimes we get a call that's, that will say, my boss is really mean to me. He yells at me. He yells at everyone. He's just a terrible, terrible boss. Unfortunately, if your boss is just a bad boss who's mean to everyone, that's not illegal. But if your boss is a boss who is mean to all of the women and very pleasant to all of the men, that might be illegal. So really, the law only prohibits discrimination and harassment based on your identity.
So then with that distinction, then, if someone is going to sue under FEHA or Title VII, what then do they need to prove to show that they were discriminated against or harassed?
So there are two things that we need to prove when we're filing a case under FEHA or Title VII. The first is that the person is an employee or was an employee who was subject to some adverse employment action. That's a technical term that essentially meant something bad happened. You were fired, you were harassed, you were demoted, et cetera. And the second thing is that that adverse employment action happened because of your identity. For harassment claims, there are two different types of workplace sexual harassment claims. The first is quid pro quo, which is when an employee feels pressured to do something in exchange for a work benefit. So that's the, I will hire you if you sleep with me. I'll promote you if you sleep with me. That's quid pro quo. That's less likely in 2021. Typically what sexual harassment looks like these days in workplaces is called hostile work environment, which is that the harasser is doing something that is unwanted, that's creating a work environment that is hostile, offensive, or intimidating.
Got it. So Minouche, I'm not ignoring you here. I'm just going to continue with Aditi just on this theme, and then I promise I'll go back to you. So Aditi, we often hear sexual harassment cases, time and again described as he said, she said. Why is it framing it in this way problematic?
So unfortunately, the frame of he said, she said, essentially what that means is that when we take a sexual harassment case, what it comes down to is who we believe. And the hard thing about that is oftentimes that's all of the evidence that we have in these types of cases. For any kind of case, when someone calls us, one of the things that we ask as an attorney is, do you have any evidence? Do you have any text messages, emails, photos, videos, journal entries, anything, any witnesses who are around, anything that shows, anything that can back up what you said happened? Not because we don't believe them. Of course we believe them. It's because when we are going to be in front of a judge or a jury, we're going to have to provide evidence to back up what they're saying. And the hard thing about sexual harassment cases is that there's almost always no evidence. It's almost always just the harasser and their target in a room with no cameras, no videos, no witnesses. The harasser doesn't send an email saying, I confirmed that I sexually harassed you. There's almost always absolutely no evidence in these cases except for the two people's word. And it's not that we can't take that can't be sufficient to file a case. It's a lot harder because then it comes down to who the jury believes. Mm-hmm. And obviously not being believed is a whole trauma in and of itself. And so it is really hard to take those cases and to win those cases.
Okay, so when someone comes to you and say they want to file a lawsuit, what do you warn them against?
So the law is not a perfect system. As we've talked about, and even a good outcome really can't make you whole. And so there's sort of three main things that I tell a client before they formally sign up to be a plaintiff. The first is that the law can't make you whole. It can give you money, it can give you a change in policy, it might be able to give you some other stuff, but it's really, a lot of people come to this hoping that it's going to get back what they lost, and it just can't. The second is that the process of a lawsuit is often very long. Jennifer's case just settled, and we filed that 4 years ago, and that's not abnormal. Sometimes lawsuits just take that long. So you're wrapped up in this for years and years and years. And the last thing that we warn people about is that the process of a lawsuit can be really difficult and invasive. Once we file a lawsuit, both sides get to engage in something called discovery, which is where we ask them questions and they ask us questions. The questions can be written or they can be verbal, like in a deposition. And oftentimes with sexual harassment cases, the types of questions that they can ask sometimes are really, really invasive. We have had cases where they've asked about previous affairs that our clients have engaged in. Did the client flirt with the harasser? Are there other reasons why the client was depressed or anxious during that time? Did the client's mom die? Did the client have a miscarriage around that time? I mean, you can get really, really invasive into clients' records and histories. And so we always warn our clients about that like if there's something to find, the other side is really going to try to find it. And we will do our best to keep it out. But sometimes the judge will say, you know what, I think it's relevant that this client experience this terrible thing around the same time. So, so that's a huge downside, is that really their lives are sometimes just ripped open and all of these things get out that really shouldn't be out and shouldn't be relevant to the case, but they get in there.
I just want to add one other positive that people can get out of filing a case, which that it can be an opportunity to tell their story. So just in the same way that, the brave people participated in the documentary and were actually able to be heard and validated and see other people going through similar situations, that can also happen in a lawsuit. It's an opportunity for somebody to tell their story, sometimes an opportunity to be believed. And so sometimes that can be very empowering for people, despite all of the negative aspects that Aditi discussed.
Mm-hmm.
And is this really the only mechanism that we have to hold someone accountable?
It is in the system that we currently have, this is the way that we hold people accountable, really. If we want to show, formally, officially that you have been wronged and someone needs to actually pay for that, whether that's firing that person, whether that's, providing you with money, this is really the way that it's done. And so it's an imperfect system, but it is the system that we have. And there are other upsides too. I've talked about all of the downsides, but some of the upsides, one of the major ones is what Minouche talked about, is that it is a forum for you to tell your story. And that is for yourself, that's for others, that's for changing the culture, that's for moving things forward, which we saw Drew do with On the Record. It also, you can get some things out of it. So you can get money, you can get compensation for the emotional distress that you suffered. You can get compensation for lost wages if you were fired or had to take time off of work. You can get it for therapy bills, medical bills. So you can get money. And then you can also get changes in policy, changes in training. And so one thing that we got with our case against the Navy is we got extra training on sexual harassment for everyone on that naval base. We got notices posted on all of the bulletin boards telling people about their lactation rights and how they can ask for them. And we got lactation rooms. When Jennifer started, there were 0 lactation rooms, and now there are a dozen across the naval base. And so, you know, Jennifer will say that she filed this lawsuit for herself. She filed it for her colleagues, who now are able to come forward more easily with lactation and sexual harassment claims because they know how to do so, because their rights are posted all over. And for systems change, for culture change. I mean, you know, she didn't have lactation rooms, but the next generation won't have to fight for that on that naval base. And so it's not a perfect system, but this is really one of the only systems that we have to create change in, you know, in our world.
And then speaking of change, and either one of you can address this issue, which people are talking about more now and states are addressing, and those are non-disclosure agreements.
Mm-hmm.
Please tell us, because there's a lot of confusion as to, can we be forced to sign NDAs? How do those NDAs hold up? You know, so can you just address, you know, either one of you can address that?
Yeah, so NDAs are very state specific. So if you are outside of California, I really recommend that you look up what the law is in your state specifically. In California, and this is a little known fact, it really hasn't been publicized very much, NDAs are not legal in the state of California for discrimination and harassment cases. NDAs are non-disclosure agreements. Typically, the way that it works is when you settle a case, the harasser or the company will say, we will give you this money, but you cannot talk about this case. You can't talk about what happened. You are essentially gagged. You don't mention it ever again. Otherwise, you have to pay the money back. In 2019, California passed a law saying, for sexual harassment cases, that NDAs are illegal. And then just this year, just a couple of months ago, California passed another law saying now for all discrimination, all harassment cases, NDAs are illegal. So those should not be in any settlement agreements that happen in California under California law.
Well, I love living in California. Thank you for that, because there is a lot of confusion. So thank you for clarifying that. And then before I go on to Minouche, can you just, Aditi, talk us through, if somebody who's watching now, you know, has been a victim of harassment or assault, what is the process in California of filing a lawsuit?
So the first thing we'll advise is that you really should talk to an attorney if you are at all interested in filing a lawsuit. I know a lot of people are worried about the expense of attorneys. They can be very expensive. Employment lawyers typically work on what's called a contingency fee basis. And so they will take a percentage of your winnings. So if you don't win, you don't have to pay them. That's typically how they work. Mm-hmm. So typically there's no upfront cost. So the process is that you go talk to an attorney, collect your evidence if there is any. If you have any text messages, if you have any photos, if you have any witnesses, you collect your evidence and provide them to your attorney so they can look into it. Then what the attorney is going to do, or you can do on your own if you don't want an attorney, is file a claim with a government body called the California Department of Fair Employment and Housing, or a federal body, the EEOC. That essentially is a claim is just like a description of what happened. And if you want to file a lawsuit, you click on, I want a right to sue letter, which gives you authority to go ahead and sue, or you can ask them to conduct an investigation. So that's essentially the few steps that every person who files a lawsuit for discrimination or harassment in employment in California has to follow. You have to file a claim first.
Got it. Thank you for that. In the beginning, Minouche had mentioned that employment is not the only place where we see sexual assault and harassment taking place. Does the law protect people against sexual harassment and assault in other places?
It does. So the law is actually, it attempts to cover sort of the big spaces that people are in. So we have a law for, against sexual harassment and assault in employment. We also have one for education, housing, and business establishments.
Got it. Thank you. Okay, Minouche, now coming over to you with a lot of questions here. So this is really interesting. You know, I'm not an attorney, and you're answering so many questions that I had. And again, I live in the wonderful state of California. So let's start with housing. Minouche, what protection does someone have if they're being sexually assaulted or harassed in their housing?
So as with employment, there are both federal laws and state laws that protect people from discrimination in housing, which would include sexual harassment, sexual abuse. So in California, the Fair Employment and Housing Act, which is the same law that Aditi talked about that provides protections in employment, also covers sexual harassment in housing and is very broad and protects people in all kinds of living situations, including homeless shelters. There's a federal law, the Fair Housing Act, and that also provides federal protections against discrimination in housing, although like in employment, the California law is broader in terms of protections for people in housing than the federal law. And we've done a lot of outreach and advocacy on behalf of unhoused residents in California, and we have found that sadly, persons residing in homeless shelters face sexual harassment and abuse, and it puts them in a really horrible situation where sometimes they have to choose between sleeping on the streets or enduring that abuse. And as in the employment situation, the harassment can be like a quid pro quo, like, requiring sexual favors in exchange for housing or shelter, or it can be like a hostile housing environment where people are constantly exposed to verbal harassment or unwanted sexual advances. And we actually have a lawsuit that we've brought against several homeless shelters in Orange County and the local governments that fund them because multiple women experienced very sexually invasive searches that they had to endure to literally enter the shelter. And then other women were verbally harassed, spied on when they were changing, groped by male staff at the shelter. Some of them were basically told, hey, if you sleep with me, I'll get you a better place to live. And this took place in cities where they were threatened with arrest if they were living outside. So they were just put in this really horrible situation. They could face arrest if they were outside. They could go into the shelter and face being harassed. So again, we're very lucky that in California, we have very broad protections for people in housing, including in homeless shelters. And so we're able to bring a lawsuit for them under California law.
What can someone do if they are victimized and experiencing sexual harassment and assault in housing?
So as in employment, they can either file a claim with a government agency like the Department of Fair Employment and Housing, which is the state agency, or the federal housing agency, which investigates housing discrimination, is HUD, Housing and Urban Development. Unlike in employment, they don't have to go through that administrative process first. So they can choose to, but they can immediately file a lawsuit if they want. One difference between the housing situation and the employment situation is how much time they have to file a complaint or bring a lawsuit. So for employment situations in California, people have 3 years from the date that they were harmed to start something. In the housing situation, they have 1 year. So it's a shorter time than in the employment situation. And again, as with employment, we really advise that people consult an attorney who can help them figure out, do they want to file a government claim? Do they want to straight file a lawsuit? And what laws make the most sense in their situation?
Well, we also hear this is happening, in schools and businesses as well. So, what can people do there?
Yes, and similarly in schools, there are federal laws. People have probably heard of Title IX, which is a federal law. And then under California law, the California Education Code also protects California public school students from sexual assault and sexual harassment, whether that's being committed by other students or by school employees. And school districts and colleges and universities have to have very explicit written sexual harassment policies. They have to provide information on how to report sexual harassment, and they have to have that very visible. It should be available easily on their website or some other way so people know about their rights. And if the schools are not following that, people can file a Title IX complaint or a similar complaint under state law. And people who are being harassed can request immediate and reasonable action that will make them feel safer while the school investigates the complaint. And again, Title IX applies to schools that receive any federal funding, which could include some private schools. And as in the employment situation or the housing situation, it's illegal to retaliate against someone who reports that they've been harassed or speaks out about sexual harassment.
And since you mentioned Title IX, I would like to encourage our viewers to see the documentary, The Hunting Ground, which was also made by Amy Ziering and Kirby Dick, who are the filmmakers behind On the Record. It's an award-winning documentary. It goes into sexual assault on college campuses in it, and it addresses the issue of Title IX. So I encourage people who want to learn a little more as well to watch that documentary. Minouche, to you again. We know that the sexism and the misogyny that was exposed in On the Record and in the work that you do every day runs very deep in our culture. All of the solutions that you both have talked about here today are about what can be done after someone has been sexually assaulted or harassed. Is there anything we can do on the front end of this to actually prevent assault and harassment?
Yeah, that is such an important question. And fundamentally, sexual assault and harassment are violations of respect and consent. And so it is so important that we start teaching those values early and often. And an important way to institutionalize these norms is to have broadly available sex education curricula that incorporate instruction on healthy relationships and including consent and respect. And in California, again, we have some very strong laws that require all public schools, including charter schools, to teach comprehensive and inclusive sex ed at least twice to every student, once in middle school and once in high school. And such instruction has to provide information about how to form and maintain healthy relationships. It covers consent, harms of negative gender stereotypes, sexual assault, teen dating abuse, and intimate partner violence. And so, one way that parents, students, and advocates can get involved is making sure that the curricula schools are teaching are actually living up to the law. And I need to circle back to The Hunting Ground that you mentioned, because not only is that amazing documentary, but it's a primer on how to be an activist, because you see these amazing young women who are survivors and who take the pain that they have suffered and just courageously step forward and transform, how schools need to respond to sexual assault on their campuses. So it's an amazing documentary for many reasons.
Agree with you 100%. Admire. I met many of those survivors, and they're just all remarkable and very committed to making sure that they're using their voice, to help other survivors and to bring enough awareness that, we can address this issue on college campuses. So I think we've run out of time here. I just wanted to thank you both so much for joining for this very important and informative conversation. I just want to tell our viewers that you can find resources related to this discussion on the registration page for this event, or by looking at the description of the video where you are watching. And also please go to the ACLU SoCal.org website. Got a lot of information there, a lot of resources. I've been a member of the ACLU for over 30 years. It is one of the most important organizations to protect our rights. So I'm very proud, not just to be a member, but also to be on the board of trustees of the ACLU SoCal Foundation. So thank you everybody for joining us today. Again, any questions, go to the website, and wishing everybody a lovely day. Thank you.